1.
I find myself in a very precarious situation, and this can be confirmed by a High Court judge who stated this is a somewhat unusual case. Let me explain. A debtor's petition relating to an application for bankruptcy was made in December 2009, which was not seen or signed by myself. This so-called bankruptcy was later discharged in 2010. In addition, I believe that my disabilities have not been taken into account with regards to my being unable to attend court, and the matter needs to be properly reviewed. This factor was completely ignored. I was actually housebound at the time due to my broken electric wheelchair. This was not taken into account at all. There needs to be a proper hearing as confirmed by yet another judge. There have also been many mistakes and wrongdoings with the court proceedings, especially lifting information from elsewhere, causing ongoing inaccuracies, and not to mention fabrications. A finding has to be defined by a set of circumstances that is looked into independently and not merely based on what a third party states. At one point, the trustee and the Insolvency Service even claimed that my solicitor through legal aid was actually a creditor. In addition, a registrar glossed over this case altogether. Due to the above, I have recently sought out advice regarding the court case. One particular contact who provided me with such guidance stated as follows: the case concerning Anna C. Young marks the ineffectiveness of the interface between the Insolvency Service and the general public, especially those members who are dependent upon financial and social support from outside agencies, including the state. The lack of expertise in the Insolvency Service means that there is a potential for miscarriage. An application for personal insolvency submitted by a third party would, if checked, show that the application was wrongly named and did not sign the application. A trustee was appointed. An accountant firm related to this case stated jokingly, "We are the best at getting every penny out of a creditor of the named trustee named by this firm. He's good, but maybe he does not like people." Again said with a laugh. Anna Young was told by the accountant's trustee that he did not want or need to speak to her. The trustee produced previous notes of bankruptcies, although named, could not produce reports of their claims. There seems to have been a dispute as to the mental and physical state of Anna C. Young, despite a report on her condition from the highly reputable Tavistock Clinic. The trustee seems to have persisted in claims citing debts to Notting Hill Housing Trust and ignoring a clear sheet from the body, and also ignoring the fact that Camden Council failed to notify a change in housing allowance, which the Council and Notting Hill Housing Trust refrained from advising Anna C. Young for 23 months. Reverting to the apparent slovenly nature of the Insolvency Service, with regard to new applicants, there appeared to be no advice on describing the nature of creditors, which results in the organisation naming fully satisfied organisations as creditors. I am not surprised that there are grave irregularities when the bankruptcy application was completed by an unknown third party. My rights, as well as my human rights, were clearly intentionally infringed upon, and therefore there is a prime example of bad faith. The Deputy Registrar, on the 10th of January 2010, should have taken into account the actual circumstances, and he did not do so. This is obviously a difficult case that I found myself embroiled in. I was in fact solvent on the 4th of December 2009, and today that status still remains. Contrary to the Disability Act, no reasonable adjustments were ever taken into account at any time. As previously mentioned, I do have cerebral palsy and other health difficulties. I spent a period of 14 weeks housebound and was not able to do anything about the situation, and therefore could not attend court. The statement of affairs was not even written by myself. Having obtained a copy, I can confirm that the said application was in fact poorly written. I am appalled by the quality. It would not make Oxford University standards, let alone Harvard Law School standards. Clearly to date, the court has never actually read anything I have tried to convey. The Insolvency Service, it would appear, did not read the application form either. The whole sorry case of this situation is unjust at the highest possible level. The case is, as I have previously cited, exceptional, and so much so that the Parliamentary and Health Ombudsman has very recently taken on the case. Furthermore, to be defined as a creditor, one has to have a signed contractual agreement which would incur statutory interest at 8% if one failed to pay any liability that falls due. In my case, no one has lent me money, and I have never borrowed. The whole sorry case is holding me back. I simply want this ridiculous case to end so I can get on with my life.